share my screen, and then let's get started with our day number 5. I think this is day number 5, right? Or is it day number 4? I'm trying to remember. No, this is day 5. And what we did, what the only difference is that in this case, we split up the contracts class into 2 different classes. So that's the only thing. Give me a second here. Let me get in here. All right, so we kind of talked about, I'm just going to go really quickly about communication, compliance, knowledge, and of course, commission. And then the ways for a buyer to get out of a contract. We talked about that. We also talked about the one way that a seller can get out of a contract, and that is really when the buyer does not deliver the earnest money. All right, so now we're going to do 2 things for the remainder of this class. And it may, I mean, today, honestly, the class may not go more than 20-30 minutes. Give you guys a break. I'll probably give you guys 15 minutes back from our normal schedules. We're going to talk about 2 things. One is the time-sensitive clauses within the contract and the addenda. And then also we're going to talk about, we're actually going to go into and review the 1 to 4 family, the third-party financing addendum, as well as the appraisal waiver and the HOA addendum. So we're actually going to go through those contracts. Might extend a little bit more, but we'll try to keep it as brief as possible. All right, you know the routine. You guys have to have your videos on so I can see you and I can ask questions. And it looks like we got a good group. All right, so let's start with the first question here. All right, so if you remember and this is more just for you guys to kind of remember going forward. All right, who can tell me how many days do you have to deliver the earnest money? All right, so very good. So I guess, yep, I think Meghna just pretty much set it up. She just pointed at it. So Meghna, tell us what it is.
3 days.
Very good, very good. And that is it calendar days or is it business days, or how does that work?
I think it is business days.
No, it's a combination of both.
Both.
And so what I want to do is I want to explain that. And I want you guys to know the difference between the delivery of the earnest money and the delivery of the option money, okay? Mm-hmm. So let's say you have an executed contract, and there is a, you know what? Let's see if I can find it. I'm gonna go off on a tangent here. Give me 1 second. All right, let's do this real quick. Let's see if we can find the actual, let's see here. Let's see here. Let's see. I don't know if it's in the Trek or if it's in. Give me a second. I'm gonna actually try to see if I can find the calendar. There's a calendar in Trek, believe it or not, that earnest money delivery. Let's see if it's if the calendar is here. Let me see if I can find it.
I think even in the back agent, if you add your transactions in contract, it tells you.
It sets it up. Yeah, I was looking for. There's a calendar that actually kind of goes over, like if the I can't find it. So let's just go back. Sorry, guys. All right. I'll see if I can find it. I know Rachel had it in one of our discussions in the past, but what it is, let me go back to this real quick. The 3 days, let's say, for example, if you execute the contract on a Thursday, day number 1 is Friday. Day number 2, I believe they consider Saturday. Your earnest money has to be delivered by Monday. However, if Monday is a holiday, then the next viable day is Tuesday. Does that make sense? Kind of, you know, so that's how it goes. I got to go find that calendar because it's a great calendar to have, just to kind of understand exactly what. Here's the rule of thumb, though, is, you know, again, the only thing that, it's not the only thing. What can hurt you is if the seller gets another offer and you have not delivered the earnest money within 3 days. You guys understand that, right? Because that allows the seller to opt out or pretty much say, hey, I'm going to go ahead and terminate the contract with you guys. All right. Days for seller to deliver commitment of title. Any ideas, or what do you guys think should be a good number of days to deliver commitment of title? It's actually in the contract. Does anybody know?
It's 3 days also.
No, so delivery of commitment is actually a little bit longer.
Is that 7 days on that one?
Actually, more than that.
Oh, is
20
it?
days.
20 days. Very good.
20
Who
days,
said
yeah,
that?
20.
Yes, Gokul.
Gokul, very good. Again, yeah. So the delivery of the commitment of title is 20 days. Now, guess what? If you have objections, and I have objections 2 lines down, objections to title within. So here's the caveat to this that I want you guys to remember is now you got 20 days. I mean, obviously the title company is not going to take all 20 days to deliver the commitment. They're going to take maybe a week or, 10 days to deliver it. Obviously the reason, and do you guys understand why the time of 20 days is there? Anybody think of why the delivery of commitment is so long? What does the commitment to title do for you? Think about that.
Provide the title insurance.
Yep, it's title insurance, right? At the end of the day, it insures title. It's an insurability to the title, meaning it's free of defects. There's no liens against the property, right? There's no encroachments, or if there's any encroachments, then those are cleared. Let me give you an example, right? If let's say if there's a death that happens in the property, now all of a sudden you got to go through the inheritance, you got to go through the heirship affidavit, you got to go through all of that stuff. That may not, that mean you're not gonna be able to get that done in 7 days. That's gonna take some time. The good thing is you have the objections to title that allows you to X number of days to object to certain conditions within the title. That's basically what that is. All right, survey to be delivered within how many days? What do you think is, now some of these are not exact numbers, but just give me an idea of what the survey should be. Anybody, any thoughts to that? Let's see, we're gonna call on somebody.
That's negotiable, right?
Yeah, it's negotiable. So just give me an idea of what would be a good number for that.
5 days.
5 days, yeah. And I think I have 3 to 10 days. So
3 to
you see, yeah, 3 to 10 days. 10 days is so here's the thing. If you're getting a new survey, if you have to get a new survey, then make it 10 days. If you have an existing survey, then make it 3 days. And here's a good rule of thumb. If you're the listing agent, you don't want any of these numbers to be variable. What are you going to do? If you're a listing agent, what are you going to do for within your MLS? Let's call and watch. Huh?
Put everything on all the sheets on the MLS, so this way they have access to it immediately.
Yep,
Transaction
exactly.
list, yeah.
Yeah.
And
Very
also
good.
put
Very good.
And also put the T47.
I actually, you just answered my next question. So we talked about the T47. Badivu, what would be another thing that you have to add into the MLS just so that way, remember these timelines, if you're representing the seller, you want to make sure that all of this stuff is already in the MLS so you don't have to worry about it. What would be another one that you want to add? So Meghna mentioned T47. There's 3 documents for sure that you want to add.
Survey and the seller
Seller's
disclosure.
disclosure.
Yep, bingo. Those 3, when you get that listing agreement, what I do is if you look at that listing package email, I think it already has the documents ready, and basically just have them filled out by the sellers and say, hey, before we put this on the market, please send these back to me so we can go ahead and just get it on the MLS right away, along with the descriptions and all that stuff. All
So
right,
the
good.
T47 is not needed if the house is like 1 year old or something, right?
No, you need
It
it
is-
anytime.
anytime we need.
Yeah. As if the seller has an existing survey, then the T47 is needed, because at that point, that basically, what is it called, verifies that there's been no changes to the survey or the fence line or the boundaries, right? Because if, let's say within that year, 6 months later, they put a pool in, what happens to that survey? What happens to that survey if you have a pool added, regardless of 6 months down the road or a year down the road?
You have to order a new one.
Very good. You have to order a new survey because now you've changed the scope and the boundaries of the I mean, not even boundaries. You've changed anytime. I think it's pool would be one. I'm trying to remember if I know outdoor patios probably don't qualify for it.
Even
But
the
if it's,
fence, Ketan, I just had the title order a new one because the fence was moved a little bit and they ordered it.
yeah, they have
So-
to, yeah, because they're not gonna insure it otherwise. Yeah,
Mhm.
absolutely. Yeah, if the fence has been moved, then they will ask for a new one. All right. Going back to objections to title within 5 days. That's what we have in the contract today. All right. Seller's disclosure. How many days does these, so this is a trick question. I'm trying to remember which one this is. Yeah. All right. So this is actually, what's the standard you should have if the seller's disclosure is not in the MLS? What would be a good suggestion? So I am going to ask, did we call on Bernard? Bernard, I don't think I called on you. So what would be the number of days you want to make sure that the buyer has that seller's disclosure within?
3 days before closing.
No, not before closing, but 3 days upon contract execution, right?
Yeah,
Does that make
yeah,
sense?
yeah.
Yeah. So in other words, and this is another one that is a variable, meaning, you can put it down as 1 day, you can put it 2, 3. I wouldn't put more than 5 days though, because you don't want to give that delay. I mean, now the delay for the buyer is great because now you have 5 days. How many days do you have for the buyer to terminate due to the seller's disclosure upon receipt of the seller's disclosure? So now if you have 5 days that, if he gives it to you in 5 days, how many days do you have to terminate?
7.
Does anybody know? Very good.
7
7
days.
days. Yep, 7 days it is. Yep, exactly. So buyer may terminate. Remember what we talked about? These are the ways out for the buyer that you guys have to be aware of. You don't need it today. You don't need it tomorrow. You might need it a year down the road or 5 years down the road. So these are things you want to be aware of, because ultimately, what is your goal? It is always to protect your buyer's earnest money. And obviously close on the house, but at the same time, protect the buyer's earnest money. The next one, termination option. How many days? Very important.
Again, negotiable.
Yep, very good. Negotiable. So this is where there is a hard timeline that's associated with the option. Does anybody know what that is? So in other words, if you have 5 days on the termination option, day one starts. So let's just give it an example. So let's say Thursday the 15th, okay, and I have a 5-day option period. When does my option period? And I need the exact time and date. Well, I think I just gave it away. But give me when the option period ends. If it's a Thursday, the 15th, 16th is day one.
20th on
20th.
5 p.m.
Tuesday by 5
Exactly.
p.m.
Tuesday by 5 p.m.
So here's the thing, Tuesday by 5 p.m. So here's a couple of things I want you guys to remember with this, right? Do not wait till the last minute, number one, to terminate. Number two, if your buyers are absolutely certain they're going to terminate, do it early on so that way there's no confusion, there's no mishaps. Let's put it that way. Here's the other thing is, if let's go to that example, 5 days on the option. Thursday is the executed day. So you have Friday, Saturday, Sunday, Monday, Tuesday, right? And the inspection is not going to be done until Monday. All right. So what I do is 2 things. Usually I will, if I get the inspection report on Monday, knowing that Tuesday just is not enough time to negotiate repairs, right? What I'll do is I will send out 2 separate amendments. Okay. I will send out this amendment for repairs, which let's say, even if it's just 1 or 2 or 3, whatever repairs that are required or requested or suggested, right? By the buyers, right? So I'll send out an amendment for the repairs. And on top of that, I will also send out a request for an extension to the option. All right. Now I'm going to ask somebody, let's see who, and I want to ask Kavita. I haven't called on you. So Kavita, this might be a tough one, but why would I send out the amendment for an extension, say another day or 2, even though I've sent the repairs amendment really just 1 day before the termination? Any thoughts to that? Or does anybody have a reason? Yeah, go ahead.
Yeah, I'm not sure on this, Ketan. So if everything is in there already in place, why would the buyer extend the option?
it to
Maybe
get some-
they missed the 5 p.m. cutoff line
No,
and
Is it
let's see
to
if
get some
anybody knows.
negotiation
Nego-
time?
Yes, yeah. So I don't know who said that, but that is exactly
That's-
correct. So what I'm doing there is out of respect for the sellers, and I'm actually telling the sellers this. I'm saying, hey, I'm telling the listing agent, hey, out of respect for your sellers, I know we're not going to give you enough time to go over. If I have a list of 10 repairs, I mean, the seller wants to go through and say, okay, how much is this going to cost me? Am I going to do this? What does the repairs look like? If I send it to him on a Monday afternoon, knowing that he has until Tuesday, or we collectively have until Tuesday at 5 p.m. to make this decision, I'm going to say, I'm going to give you two options. You can go ahead and, at least at the moment, sign the extension and then continue reviewing the amendment. Does that make sense, guys? So what I'll do is I'll send the amendment. I'll send two amendments, because remember, your amendment, there's 4 different pages that you can use, right? So I'll send an amendment for the repairs, and I'll send an amendment saying, hey, I'm going to go ahead and ask for an extension for 2 days. That also gives your buyer, flexibility as well, right? So, and it's a good courtesy that you want to kind of, because the last thing you want to do is send in an amendment for repairs at, 5 p.m. the day before, right? And then just give them 24 hours, or even 8 p.m. Or I've seen that all the time. They send out that amendment, the next morning, and sellers don't have, even myself, if I'm representing a seller, I barely have 5-6 hours to get it back to them. All right. So hopefully that kind of makes sense how I do it and why I do that. It's not a requirement. You can do it however you want to. Sometimes the seller will come back and say, you know what, I don't need that time. We're going to agree to doing this, or we're not going to agree to do it at all. Then it's up to you to talk to your buyers. And remember, at the end of the day, let the buyer make that decision of, is he going to move forward, or what he or she is going to do. All right. So
So
next
the
one.
extension of the option period, sellers usually won't agree, right? Especially in this market.
Yeah, in this market, absolutely not. They will probably, you're right. Yeah, they will probably not agree.
Because they're already
Um,
asking to shorten it now that the
Yeah.
Ketan,
Yeah.
what are the exact form names?
The exact amendment, it's just called amendment, AMENDMENT.
Gotcha.
Yep.
Okay.
And then
So,
on the amendment, so remember, I don't know if we can talk about the amendment as well here, because the amendment is where you're going to use for whether it's changing the buyer's name or adding, a spouse
Right.
to a contract, page 9. If you're changing the closing date, section 9. If you're changing the closing date, it's section 5, I think. If you're adding closing costs in lieu of repairs, it's section 4. Repairs is section 2. Change in sales price is section 1. So anything related to amending the contract always goes into the amendment. And here's the other thing is, if you're changing, and this is, I know we're going on a tangent, but I want to make sure you guys understand this. If you're planning on extending out the closing date, do not wait till the last day. Again, give the sellers enough time to talk through it. And this goes back to being, good communications, working with sellers on these things. All right, last one, delivery of option fee. This is an easy one, or everybody should have this memorized. And Ehsan, you tell me which one that is.
So within the 3
How
days
many
that we
days?
have,
3 days. Right? It should be still 3 days, but now the only difference, it is 3 days, right? I think it is. It should be.
yes,
Unless they change, yeah, 3 days. It's always been 3 days. Here's the critical piece to this, and this is why it's time sensitive. If you do not deliver that option fee within 3 days, what happens? Raj, do you know?
You're not getting those option periods.
Exactly. Your buyer loses the right to terminate under the option extension or the option clause. Absolutely. Yep.
But the
That is
contract still
important.
remains valid?
Yeah, contract is valid. It's just that your buyer does not, obviously your buyer can terminate based on financing or on survey or seller's disclosure or whatever. But they just don't have the ability to, and that's why if you look at a lot of the contracts today, they may not have an option period, or they may have $2,000, $2,000 or $3,000 in option dollar amount is common nowadays. But, they may not even have an option period. The reason is because they don't necessarily need that to terminate the contract. They have 10 other, we already talked about it. There's 10 other ways for a buyer potentially to terminate a contract. All right. Let's see.
Okay, Ketan, quick question on that one. So
Yeah.
that means that within 3 days, 5 p.m. would be the cutoff for this one also to deliver the auction fee?
No, that's a good question. No, it's within 3 days. So let's say if the contract was executed on Thursday, the 15th, 16th, 17th, 18th. So Friday, Saturday, Sunday. Yeah, technically. So here's the only thing I need to go back and look, because if you think about it, title companies are not there on Sundays, right? And the delivery is calendar days. So then you have to deliver it by, and nowadays the change is you have to deliver it to the title company, right? So either you're going to do that Zalcam payment, meaning, it's almost like, doing an ACH or Zelle payment directly to the title company, or you're going to do a wire transfer or whatnot. But it is 3 days. There's not a time base. It's not based on time. Does that help?
Yep,
But it's 3 business days, right? It's not 3 days per se.
Has they
It's not
changed? And I should know that, but yeah, so it is now
It's
3
not
business days.
business, right?
Okay.
I mean,
I'm sorry?
isn't the options money only calendar days? Like it doesn't matter whether it's Sunday or any holiday comes, we still can't.
No, it was before, but now that we have to submit both of it to the escrow company, the title company, now it is business
3
days.
Three
business
actually.
business
Correct me
days.
if I'm wrong.
Yeah, and we're going to go
I
through the
think
contract. That's exactly correct. Yeah.
this is same as the earnest money, I think.
Yep, they're
Correct.
both
Makes sense.
delivered to the same place. Yeah, and that's the change. I'm still going through the contract, but that is the same change that we did effective April 1st for the new contracts, right? The difference now is ultimate. Before it was 3 days, and obviously depending on when the title company was open. Now, but the option, if before, 3 days meant that you had to deliver, if you did an executed contract on Thursday, you have to deliver it Friday, Saturday, Sunday. By Sunday midnight, you have to deliver that option money to the sellers, whether you went to their house, delivered it to the real estate company or the listing agent's office, or to the listing agent directly. Now it's changed. You're right. It's 3 business days. That's a good point.
But it is now like straight to the title company, right? Not anymore.
Yep. Remember that both the earnest money and the option check are delivered to the title company. Yeah. And there's 2 things you can do. You can either do 2 different checks, or I think the title company allows for 1 check, if I'm not mistaken.
Yes, check is fine.
One check is good, yes.
1 check is
Yeah.
good. Thank you. Yeah. Yeah.
And Ketan, correct me, one big change I can see is earlier, the options money was payable towards sale or not, right? Earlier.
No.
But
But it's still the same way though, isn't it?
no. Now it is definitely part of sales price.
Yeah.
From April onward, but before April, I think it was optional.
Yes. Very good point. Yep. Yeah. So it used to be whether it was going to be credited to the sales price or not.
Yes.
Absolutely correct. Yeah. Now it's automatic. That makes sense. Yeah. That is true. Very good.
Add one more question. So now the options money, since it is collected by the title, I forgot, I'm not seeing the closing disclosure, but does that go to the seller at the beginning, or is it in the closing document?
So 2 things, right? If you do end up closing, then it's a credit to the buyers. It's a deduction to the sellers, but it's a credit to the buyers. And then so it basically goes towards closing. At that point.
Okay.
Yeah. Yep. And then as far as, but if the contract doesn't go through, then, and if it's within the termination option, then the title company will then take that $500 and deliver it, or, ask the sellers, how do you want the option check delivered to you?
Yeah, makes sense.
Yeah. Yep. All right. Let's go to the financing addendum. There's only 2 things in here. Buyer credit approval then So remember with prior credit approval, that's the bottom of first page. It used to be 21 days. What's a good number of days nowadays? So I'm gonna call on
15.
somebody. Alpa. Yeah,
Oh, sorry.
yeah, go ahead. 15, what else? Yeah.
14 days, yeah.
Well,
Anywhere
if it
between 10 and
is pre-approved, it could be less than that.
exactly. Anywhere from 10 to 15 days is fair. Okay. Especially in today's market, I wouldn't do more than 15 days. You're not going to get the deal if that's the case. All right. Well, I take it back. This is from the old contract. So just imagine this is what I had, and I haven't had a chance to change it. This is what we put in when we did this class. What was it? Back in November. So you see how much it's changed now from 15 to 21 days. It is 10 to 15 days. All right, next question. Property approval must be met within how many days? We talked about that on Monday. So let's see, who have I not called on? And, all right, Amit, how many days do you have for the property approval?
21.
No, property approval. It's a little different. This is page, so this is on the third-party financing, page 2. It's a very short number. Does anybody know?
Oh, 14 days or
Nope.
5
So
Short.
days.
it's 3 days, 3 days.
3 days. Very good. 3 days. It is 3 days. Okay. And this is where the important of this is. Okay. And I want you to take this example and just kind of remember it from this point on. Your buyer's closing within, let's say, within 21 days. Okay. Because as Alpa mentioned, buyer's already pre-approved, right? And, he's already he or she has already delivered all of the documents that the lender needs. They have a 5-day option. So after the 5th day, let's say on day number 7, a week later from the executed contract, they start scheduling the appraisal. The appraisal doesn't, the appraisal is scheduled a week later. So that's day number 14 or 15. And all of a sudden, the appraisal doesn't come in until day number 18. What is going to happen? Do you guys know? You see the dilemma there, right? What do you have to do as an agent at that point? If you know that appraisal is not going to come in.
amendment.
Yep, exactly. Yeah. You want to make sure that amendment is delivered, because otherwise you're going to lose that 3 days option, especially if you have done not what? If you have not waived the appraisal, right? If you have not waived the appraisal, then guess what? That property condition addendum, the property condition clause in the third-party financing addendum applies. You guys
So
get that?
what is the amendment is for, to change the closing date?
Exactly. Yeah. You have to change the closing date because you can't change the amendment. You can't change the third party. That's a static number. That 3 days of closing is a static number. Does that make sense? So, and if you're closing on the 21st or, day number 21, and you haven't received, and it's day number 18 and you have not received the appraisal, then you're going to go ahead and extend out you're going to extend out that closing for a few more days, just to give, again, it's all about protecting your buyers. Does that make sense?
So,
Right.
Ketan, it recently happened to me.
Yeah.
The appraisal value that came out was very low. The appraiser used sale dates of November 2020, so which was ridiculous.
Yeah.
But because of that error, we had to request the seller to give us a 10-day extension just so we can get it reappraised by another company.
Oh, okay. So you guys actually did it a little differently. You guys actually did the reappraisal. That's a good idea too. Yeah.
Yeah.
How did it come out the second time?
Yeah, when we saw that he had used November 2020 and January 21, we were like, come on, man, you can't use data that is 6 months old.
Yeah. And so how did the second appraisal come out?
So it's not done yet. We are still waiting on the second appraisal,
Okay.
but we'll see how it goes.
Okay, but you did get the extension for the closing.
We did right away on the
Good.
same day.
Yep, that's perfect. That's the way to do it. And again, it's all about that communication. Make sure that and especially if you, now here's the thing, if you waive the appraisal, actually, if you waive the appraisal, then you want to do it as well. Why do you want to do it if you waive the appraisal in this case? Get a second opinion. As So do you guys understand why you want to?
You want to bridge that gap, right, between the appraisal and the
Yep.
what sales price
Yep.
you have offered. So, I mean, if you don't want, I mean, if your buyer doesn't have enough funds, then probably that deal will not even go through. You know, so
Yeah, exactly. Yeah, I mean, obviously you want to try to get a higher loan amount at the end of the day.
right.
Very
My
good, very
other question was, say we do an amendment, but the seller does not want to increase the closing date, then what do you do?
So that's the tough part, especially in today's market. You have, unfortunately, at that point, you don't have a choice. You know what I mean? The only thing you can do at that point is say, hey, you know what? Buyer will put another $5,000 earnest money, non-refundable. Buyer will put $10,000 down, earnest money, non-refundable, just for that closing date. Remember, you got to make it work, right? So, and sometimes the seller will come back to you and say, or seller's agent will come back. You know what? We have another offer that's 30,000 more. That's backup and ready to go. And unfortunately, that's
right, because here's the
today's
problem. The lender has already approved the like he's fine with the hard, it's all through, but only the appraisal is not come in, so
Yep.
they can't even give us a letter saying that this has not gone through. So now here we are, left with what do we do?
Yeah.
But
Yeah.
Meghna, sorry, the thing is the seller wants to sell as well. So they are not going to do anything to jeopardize the sale to begin with.
But if they have, what Ketan said is right, if they have a bigger offer and a better one, they are not going to wait.
But think about it, right? What you just said. If you have a $30,000 bigger offer, why would you go with my offer to begin with?
No, that's
Say it
so.
came
Second,
later.
that's a backup offer, right? So
Yeah,
a lot of people, what they do is once they lose the deal, they'll go back to the buyer and say, hey, we'll go ahead and put in a backup offer just in case, and we'll put it at 30,000 more or whatever. But you see what I'm saying? Now, the only thing is now you got to wait on, canceling this contract. Now you got to spend another 21 days on another contract, right? So, so 30,000 is probably not the right figure to use. 30,000 is a no-brainer at the end of the day, but what's that threshold at that point? Is it 5,000? Is it 10,000? Right? As a seller, would you be willing to take a risk for $5,000? What do you think? How many sellers do you think would take a risk for $5,000 and 21 days? 5%, 10%? Anybody? Any thoughts? Gokul, what do you think? How many sellers would actually take that risk? 21 days and $5,000.
I think they'll take it.
You think? I think not.
No, I think less
no.
than 10. Yeah.
Yeah.
I'll say less than 5%.
Yeah.
Yeah, less than 5%. But it depends on the sales price too, right? I mean, I'm talking, if it's a $200,000 house, yeah, maybe 10%. Would 5% might do it? $10,000 on a $200,000 house? Yeah, probably. $20,000 on a $300,000 house? Yeah, I would probably go for it at that
Ketan,
point.
let me ask you a question here. So expanding on Meghna's question, let's say the seller's agent found the buyer, right? And now because of all this issue, let's say the seller decides, you know what, for that 5%, I'm going to wait. I'm okay waiting for another 21 days to get a new buyer. Will the agent, because he has found the first buyer as well, get double the commission?
No, because commission is only once, right? So, but I'm trying to understand. What do you mean by double the commission, though?
I'm sorry, maybe I should have rephrased the question. Not double the commission, but does the seller's agent get any kind of compensation for his work that he has done with the buyer number one?
Nope, nothing. No, because there's no compensation there. He's going to pay regardless, right? He's going to
Because
pay.
I remember in the classes when we were taking them, we were being told that if the seller backs out of a sale completely, he is still eligible to pay the seller's agent if he backed out by himself. So I was just trying to understand whether that is applicable here as well.
Yes, that's a very good point. So we just went. I don't know if. Let me see if Manish is on. Is Manish on? No. So we actually had that scenario just recently, and I'll give that quick example. So believe it or not, the one of our agents was representing the seller, listing agent. Everything was done properly. The buyers decided at the end, because of the square footage discrepancy, and obviously it lowered the appraisal value, and they didn't have the appraisal waiver, so they went ahead and terminated the contract based on the appraisal. I mean, the property approval basically is what they terminated on within 3 days. So they did everything correct. The interesting thing is the buyer's agent, they actually went after the earnest money that the buyer was going to get back, saying that I've spent so much time, I've done so much of this work, I've done so much of that work. It didn't go anywhere, but they actually tried to say, we're going to go ahead, I'm going to go get an attorney because I deserve my commission. Does that make sense? So the buyer's agent actually went after the buyer's earnest money. So I'll bet what you're talking about, that's a very solid example. Make sense? Yeah. All right, one more here. HOA addendum. What do you think? Well, I just answered that. 10 to 15 days is the best practice. It used to be 15 to 21 days, right? Because what was the best practice back in the old days for us was that we would only, I would tell my sellers only to go ahead and order the HOA resale certificates after we've gone through the option period, right? You don't want the sellers to order it beforehand, because what if the buyers cancels it and now all of a sudden you don't get a chance to sell it for another 3 months? Then your resale certificate may not be valid at that point. All right. Any questions on these time-sensitive clauses within the contract?
So
All right.
I have one question on the closing date. So in that closing date paragraph, there is that 7 days before or after, right? Based on the objections. So can we use that 7 days and move the close date?
That's a good question. I don't know the answer to that. I'm trying to remember. I know what you're talking about, and that's a good point. Let's go through the scenario. We have 21 days for the title commitment, right? And then we have 5 more days on the objections, right?
Yes.
And you're talking about that within that 25-day period is what you're talking about, or only if the closing was maybe within 21 days of that, and you still haven't received. I got to go back and look. I know there's an extension there somewhere as well, meaning that if the title commitment's not delivered within the 20 days, I believe there's an additional extension there as well. Or at that point, the buyer and seller can agree to the buyer and seller can agree to extend it. Buyer can terminate. I don't think seller has any options at that point.
It's an automatic extension of 15 days.
Thank you. 15 days. All right. Yep. So 15 days. Yep. So there's that answer, at least for that part. Does that make sense?
Yeah.
Yep. All right. So 1 to 4 family contracts. You guys want to go through it real quick and see if does anybody have any questions on the 1 to 4 family? Let's see, where are we on that? Let me
I
go
have a
into the
question.
reports. Yep, Bernard, go ahead.
Yeah,
Yep.
when we get this HOA addendum, are they supposed to send a copy to the realtor as well?
Yes, they should. Yeah. And you should, definitely advise your buyers to look at it, but you should take a look at it as well. Because a lot of times the last thing you need is an HOA addendum where, there's been back assessments of $3,000 that still need to be paid. Now, technically the seller is still responsible for it.
Okay.
Right. So, yeah.
And any other addendums like maybe the property approval appraisals, they're supposed to send it to the realtor as well?
For the appraisal, if you are terminating the contract, then you do have to present the appraisal price.
Okay.
You have to deliver. Yeah. If you plan on terminating the contract, you do have to present the appraisal at that point.
Okay. So is the realtor supposed to get a copy of it when initially it's done?
No. So the copy only goes to the buyer. It will not go to the realtor.
Okay. Okay.
Yeah.
Thank you.
And so what you have to do is, and typically what I always communicate with the buyers, say, hey, when you get that appraisal, just send it over my way so I can
Oh,
look
okay.
at it.
Okay.
Yeah.
Okay. Okay. Thank
So
you.
that's kind of what you want to do. All right, 1 to 4 family contract, right? So IABS, again, there's 2 different IABSs. There's one for the seller landlord and there's one for the buyer tenant. We've gone through the IABS, so hopefully we don't need to go through it, but I'm going to just kind of real quickly. And if you have not, make sure you read through it. It's very important to understand what the IABS really represents and what it says. All right. Right now, we're going to go through the residential service contract. Make sure.
So which one is the one we generally add it to our signature in the email that
That's
goes
the
to
IABS.
everyone?
Yep, that's the IABS.
And that's for the seller or buyer, it doesn't matter, right?
Both. Yeah. You always want to have it. Yeah. For the seller or the buyer, you always want to have it. Yep. All right. Let me go back through here. Let me see if I can just do, let me see if I have my own property in here. I think I do. Yep, I do. Okay. All right. So we're going to go through my house so you can see exactly what we're talking about on the contracts. And this is the latest version. Yep. All right. So it has changed a little bit. So we'll go through it just real quickly. Here's what I do for the seller information. Always pull it up from the tax appraisal district. If you have it on the MLS, click on the TX on the MLS and pull it up from there. Remember one thing, it's last name first. Okay. So what I do is I go in and and Sabrina, I'm going to mute you real quick. Okay, you did. All right. And make sure you add, if it's, here's the thing, when you're submitting the offer, always add it based on the information that's on tax. If it's anything different, let the listing agent make that change. You don't want to make that change. And then a lot of times, if it is different from what's on tax, or if it's different from what's on MLS, they will, what I normally do is if it's different, I will just put the correct names on there and then just and have my sellers initial it at a minimum, so that way you don't have to go through the amendment process down the road. Buyer 1, buyer 2, legal description is both on the MLS. It's also in the county tax records. So just remember that. List any exclusions from the MLS. The exclusions are right underneath the property description. Sales price, third-party financing, if it's based on that. If it's cash, then you're going to just change this all completely to whatever the cash is. This is going to be automatically 0. And the calculations are done automatically here. This is the new piece of the contract, right? Residential leases. Now you have to actually declare if you have residential leases. You also have to declare any fixture leases, meaning, if you have a good example, water softener that you're paying $25 a month for, you need to let them know, or a security system where, it's not owned, but it is, that you're paying. If it's a 3-year commitment, you got to make sure that you let the future buyers know about that. Natural resource leases, meaning if you had reserved mineral rights, or you have mineral rights at the moment, and there's, what's that word? Is it fracking that they're doing over there by West Fort Worth, which allows, somebody to come in and dig for oil underneath your property, something like that. All right. Earnest money.
Wait,
Now here's the confusing
get a quick thing. I didn't realize you have to put in. So let's say the seller has a 3-year agreement with ADT or something. You have to put that into it.
Yes. Yeah. Because unless the seller is planning on continuing to pay for it, right?
Right. Yeah. No, I never realized that went on there. I
Yeah.
was only thinking about actual people leasing the house or
No,
renting
no.
the house.
So that's the one. First one is A, which is the renters that are leasing the house, right? B is fixture leases, which is security system, water softeners, things like that. Okay.
Gotcha.
Yeah. So if it's not owned and there's a commitment, because, otherwise are the tenants or are the new owners going to be able to use it at the end of the day? And is the seller still going to continue paying for it? Right. So that's one of the reasons.
Ketan, how about solar panels?
Yeah, solar panels. So I had a house that we sold recently with solar panels, So what happens with the solar panel, let's say it's a $25,000 commitment, right? That the seller, I mean, the buyers, the sellers have already paid to, or are paying towards on a monthly basis. What happens? It's a lien against the house. So when they go sell that house, the benefit is really for the buyers at the end of the day, because now they're going to be able to use that $25,000, commitment. But what happens is that lien has to be paid off unless the new buyers are willing to take on that lien somehow. Okay. And again, it's the same thing. It's the lease. It's the lease of that. So yeah.
All right, sorry.
You have to mention that.
Sorry,
over here.
Go ahead. Somebody was saying something.
So do we have to mention that over here? Like, does it?
The solar panel, I don't see the solar panel on
I
here.
see solar panels on B, second line.
Yeah,
It is there. Yeah, it is there. I see it now. Yep.
Okay.
I need to make this bigger. There we go. Okay. Yeah, solar panels is in there. Very good. Yeah. So that's already in there.
Yep.
Sorry,
All
I
right.
had a question. So what happens, say, the new buyer decides not to get that lien on them? In that situation, what happens? Does the company just come and take them out? Or,
The solar panels?
yeah,
No. The seller, it's the obligation of the seller to release the lien, right? And the only way to release the lien is to pay it off.
okay.
So at that point, that lien stays with them, and the title company will not, because remember that title commitment has the lien on it, right? Because as a solar company, you're going to place a lien on the property, right? If you have a pool, what's one of the things they do when you build a pool on your home? There's actually a second lien against the property for that mechanic. It's mechanics and materialmen's lien, right? Is what it is. Or it's a second mortgage, which depending on the cost of those pools nowadays is a second mortgage. So does that make sense? Yeah. All right. Here is where the new contracts are very confusing. You got your title company information, you got your title company address, then you got right underneath it, you got the earnest money, and then one line below that is where your option money is. Believe it or not, I actually made the mistake a couple of times where I completely forgot that the option money goes into, because it's a newer contract, I just overlooked it, right? So just make sure that you guys, when you're writing up the contracts, that you completely fill out that first section, which is section A, all right? You don't need the second additional earnest money. And then of course, the termination option is section B, and 4 days. 4 days is probably consistent with today's market. 3 to 4 days makes sense. But here's the thing, if you're gonna do 3 or 4 days, make sure that buyers are ready to, you got inspectors lined up. Again, negotiable today's market. 80% of the houses that we're seeing right now are buyer's expense on the owner's title policy. All right. The shortages in area, we've talked about that on Saturday's class. Basically, it's just an additional insurance endorsement is what that is. Let's say, for example, the fence line has been moved, or, when they first installed the fence, it was 1 foot into the neighbor's property. Then in order to actually remove that fence and reinstall it, you're now getting an insurance policy that the title company covers if there's any costs associated with moving that fence. Does that make sense? Now, the insurance policy right here, when it says, will be amended to reach shortages in the area at the expense of buyer, the insurance policy or endorsement is 5% of the title policy cost. So if the title policy cost is $2,000, it's $100. All right. It's not a significant number. It's not what this particular portion of the contract should not make it or break it on any deals. All right. Remember that. And worst case scenario, just say will not be an amendment, because that's what it was 5 years ago anyway. All right. So, now they just give you that option. Survey, again, within 7 days is what I have. 3 days is comfortable. 5 days is comfortable. And yeah, go ahead.
I had a question, regarding that, the shortages in, area. Isn't it a better idea, because it is a buyer, lender requirement. So it's basically, at the buyer's expense. I think that's what I check most of the time, because it's not really anything to do with the seller. But it does, if you're using the old survey, isn't it better? Because if there are any problems in the survey, I think those $100 are worth it.
Yeah, absolutely. Yeah, exactly. And so there's a couple of brokerages out there that require, believe it or not, their agents to put down survey at buyer's expense, brand new all the time. You know, I think it's not fair to the buyers, because now you're forcing them to spend $500 regardless of if the house is 1 year old and the survey is perfectly fine. Why would I go get a new one? And if the seller's willing to give me one, give me his, right? The idea was that, this is years ago where the lender said, hey, you know what, we can save a buyer. Before, 15 years ago, the buyer was always required to get a new survey. Now it's like, okay, you know what, if nothing has changed, then we're going to just use the existing survey, as long as the seller does what? The T47, which is the affidavit saying that nothing has changed. All
So
right.
do we have to ask the listing agent for the T47 if it is not already given to us within the option period?
You don't necessarily need it within the option period. You just need it sooner or later.
Okay.
Obviously, if you get it within the option period, it's much better. But yeah, you want to make sure that if the seller is providing a survey, they have to provide the T47 along with it.
Okay.
Yeah, they would have to. Yeah. All right. We talked about this in depth, rental or investment property, right? We talked about that, I think, Monday's class, and the importance of making sure that your buyers follow the right guidelines when it comes to, they're going to save $25, but at the end of the day, if the community or the HOA or the deed restrictions do not allow for rental properties, that's a whole different story. Property and association.
I missed the Monday's class, so I was just wondering, what does this, what you quoted here, objections, rental or investment? Are you saying that if they basically say that the property cannot be used as rental or investment, that's the objection?
No, this is the actual opposite. This is saying that the potential buyers may use this property as a rental or investment property.
Okay.
Yeah. So and I'll really quickly, the reason you do this is if your buyers are buying the house as an investment property, especially in a community where the HOA has restrictions or a percentage ownership that's required, then at that point, and especially if the buyer is going through the loan process, pretending that they're buying it as a primary residence or as a second home, right? This is where our just the right thing to do would be to tell them, hey, you know what, you're going to save $50, but it's not worth it, because what if the HOA in the future doesn't allow you to rent it out? But what this clause does is it allows the buyers an out if for any reason the HOA or the deed restrictions or the community itself does not allow for rentals or has a percentage ownership policy. Make sense? So always, again, this is kind of what we talked about. Make sure you do the right thing and advise your clients the right way too. That is, and especially if they're buying it as an investment property, but they're now putting it down as a primary residence. It's, to me personally, it's just not worth it. It's not worth the headache, Property and association, always mark it correctly based on what the MLS has.
So, Ketan, just a little.
I'm just a lot of these sections, right? Tidewaters. Yep. Go ahead.
Just a quick on the investment thing. Many times I've also written, could it be used as an investment later? So
yeah.
At the moment it's not going to be rented out, but will that also work with if there is a HOA restriction?
So that's a good question, because what if, here's the only thing, right, is what if the buyer buys it and then 6 months later finds out he's getting relocated, right? At that point, what do you do? Some HOAs may require it and they will allow it, but it depends on that policy again of, are they grandfathered in, or is there a ownership percentage that is required? And at that point, sometimes they're forced to sell, and that's the unfortunate piece of it. It's obviously if you're allowed to do it, continue doing it. But at that point where it's not allowed, then you just have to figure out what's the best course of action.
Right.
All right, public improvement districts, transfer fees, propane, gas, all that, just read through it. It really does, I mean, not that it doesn't apply to our properties and our contracts, but it really, you know, it's, these are the one-offs is what I call it. Again, property condition, this is the buyer has received the notice. As long as you've received the notice. If you have not, we've talked about that, right? 3 days. That's what you would change it to if they have not received a notice, okay? And then here's important, acceptance of property condition, property, the buyer accepts the property as is. That just means that based on, that doesn't, you know, refute anything that the inspection does, or you guys come up with an amendment for repairs. This just says that at the moment in time when I'm submitting the offer, that the buyer is accepting the property as is. In other words, on the MLS, the seller didn't say, hey, you know what, I'm going to replace the carpets with a fully executed contract or a full price offer. If that's the case, then you're going to put in seller to replace carpets upon closing and funding. All right, home warranty, residential service contract just means home warranty, basically. All right, now this is another change. This brokers and sales agents disclosure, that used to be in the section 4 of the contract, page 1. They moved it to a more reasonable place, which is section 8 of the new contracts, right? But again, it's 10% ownership, or it's if you are selling or buying on behalf of spouse, child, or beneficiary. Okay, or sorry, spouse, parent, or child is what immediate family is what it means. Closing date, if you can get away with 30 days on a financing, that's great. On a cash offer, if you have a 5-day option, just add another week to 10 days. So in other words, 15 to 17 days on a cash offer would be reasonable. Don't push a cash offer out 30 days, because the reason you're doing a cash offer is because hopefully the seller wants their money quick. Okay. Possession, depending on which one it is. Nowadays, most of them are coming up as according to a temporary residential lease, meaning that the sellers is going to have a lease back. One other thing that I have changed on my contracts, and I'm about to do that today, is this is gone. You know, especially in today's market, you want to keep your contracts as clean as possible. You don't necessarily need carpets or house to be, I mean, obviously you want them to do it, but it's not going to change, you know, I don't put it in my contracts anymore. Does that make sense? And hopefully you guys, I mean, you can continue doing it. You know, the way that market is today, you know, is that going to be a make it or break it deal? Hopefully not. Make sense? This portion right here, this is just if the buyer is, you know, asking for additional down payment assistance. No, sorry, additional closing cost assistance. So in other words, if you're representing a seller, if you have a sales price, I mean, if you're representing a seller and you received an offer for $300,000, but then here you have $5,000 towards buyer's closing costs, then your net offer is $295. Always remember that. And one of the things you need to do is always look for this clause on every one of your contracts, especially if you're representing a seller, because the last thing you need is, you know, you go to closing and all of a sudden there's a $5,000 bill or, you know, deduction to the sellers because it's in the contracts and you guys didn't see it. All right. Happens all the time. So remember this clause and remember this section, section 12, because that is a net reduction if a buyer asks for additional closing cost assistance. You guys understand that, right?
Just can you go over that one more time quickly, please?
Sure. So let's say the offer on the house is 300,000. Okay. And now what you're doing here is if you have $5,000 in here, that's basically saying that $5,000 of the buyer's closing costs are going to be paid by the sellers. Make sense? So technically, seller's paying, if this is blank, seller's paying $0 towards buyer's closing costs. If there's a $5,000 number in here, that's too much, right? If that's a $5,000 number in there, that means that the seller at closing let's say the buyer's closing costs are $10,000. Out of that, $5,000 is being paid by the sellers, right? So the net for the seller is an additional reduction in his sales price of $5,000. So instead of 300, he's getting 295. Make sense? Most important thing for you guys, though, remember, is always look at this and just reduce or deduct the amount from the sales price. All right, and let them know, oh, by the way, the buyer's asking for $5,000 in closing costs, and this is something that you don't get it very often. I mean, you may not get it in today's market, and I don't expect it to be. But if you have an FHA contract where a buyer only has 3% to put down, it may not have enough money to, come up with additional closing costs. They will put that in here, $5,000 or $7,000 or whatever it is. So that is, again, that reduction that you need to be aware of, especially when you're representing sellers. All right. And let's see. And then, of course, make it a habit to, if you're representing the buyer's name, phone number, email address. And if you're representing sellers, make sure that they have the listing agent fill this out. If you're representing sellers, what I do is when I get the seller's contract, I go into zip forms, or I go, not into zip forms. I go into DocuSign and I actually add this information for the sellers. So that way the title company has it when they send in or when they deliver the executed contract. Okay. It's really important to make sure that the title company especially has the seller's information. Of course, the agreement between parties, you're going to have your third-party financing, addendum for property subject to association, and a mandatory membership in a property association. And of course, the addendum concerning right to terminate due to appraisal. And the other one that's here very often is going to be now the seller's temporary residential lease. If you're doing a backup contract, you're going to have the backup addendum. Yep, right here. This is the backup addendum. That's very common as well nowadays. If you're getting into this one, addendum for reservation of oil, gas, and other minerals, advise your buyers to seek an attorney. Okay, that's the only thing we can do. And that is what TREC requires you to do. Because if a seller is reserving minerals, you want to definitely understand that. And you want to know why they're doing that. So that would be something you want to probably talk to a attorney for. All right, let's see. And then here's the other thing that's important, guys, is if you're the buyer's agent, not just filling out this information, but go on and fill out this information. If you do on zip forms, you know how you have MLS Connect. If you use MLS Connect, a lot of this stuff will automatically be populated. All right. So, when you go in here and click on this, the first one on this list will be, that broker name. The license number, I don't think gets populated, but a lot of this other stuff gets populated, and just fill it out. And I've had, who was it that missed it earlier this week? I'm not going to say anything, but make sure you get your commission. All right. And that's where that goes. 3%, 2.5%. Look at what the MLS has and make sure that you fill that out. Is it going to be a problem for a dispute? Probably not, but it's good to just make sure that, again, it's all about making sure that you're filling out the contracts properly. All right. I know I went over it pretty fast. I'm going to go over the third-party financing addendum real quick. Anybody have any
Hey,
questions?
Ketan, before we move on, can you explain that 7D2? You mentioned something about that, the paragraph 7D2.
Sure. Let me go back to it.
Thanks.
And it's the as-is condition, probably, right? Yep. Okay. Yeah. So acceptance of property condition. So let's say on the MLS, when you look at the property description, and that there are, let's say there's 5 clouded windows, and you know what I mean by clouded. They have lost their thermal seal, is what it's called, right? That's the technical term of it. So let's say there's 5 clouded windows, and on the MLS, on the description or in the private remarks, you see the seller has posted, or the listing has posted on behalf of the seller, that the seller will replace windows, 5 clouded windows upon an executed contract or upon full price offer. So at that point, what you're going to do is you're going to make sure that you don't miss that out. Now, keep in mind, because here's the reason why. You can still put it into the contract. I mean, you can still put it into the amendment when you do the repairs. But if they've already agreed to it, might as well get it in here, because what if when you send in that amendment, they don't agree to it, right? So this is the reason why when you're looking at the MLS description and all that stuff, just make sure that if there's something that the seller is committing to prior to execution of a contract, make sure to put that in there. But here's the most important thing is typically, this is the clause that you're going to use is buyer accepts the property as is. All that means is for the moment in time that you're writing up this contract, if the carpet is ruined, or if there's clouded windows and the seller hasn't said anything about replacing anything, now you can put in here saying, hey, but again, that takes away from what we call a clean contract, right? At that point, the seller is like, well, they're asking for all of this now. What else are they going to ask for? And do I really want to work with this buyer or this buyer's agent, right? So the idea is keep your contracts as clean as possible using that, unless there's something that's specified in the MLS. Keep in mind, you have the option period. You have the 4 or 5 days of the option, and then you have the inspection report. And then if you have certain repairs at that point, you can negotiate it on the amendment. And that's what you're supposed to do anyway. So does that make sense?
Yeah, so I have seen an example where in MLS, they say that roof will be replaced or being replaced currently. Then should we put that here?
Yep, exactly.
Okay.
Roof to be replaced. Absolutely. Yes. Because you don't want any confusion to come out of that in the future. You know what I mean? Yeah. So if the roof is going to be replaced, I definitely put it in there. I mean, they may be already working on it. That's fine. But if they are planning on doing it, a week before closing, then you want to definitely put that in there.
Okay.
Ketan, section 21, if we don't know the seller's information, do we put the listing broker's info in section 21?
No. So, but you're representing the buyers?
Yes.
Yeah. Now just fill this out. Just fill out section for the buyers. And what I say by having have listing agent fill that out, that's just, you don't even need to put that in there. Have listing agent fill it out. Let the listing agent decide how they want to do it.
Okay, gotcha.
Yeah, we don't need to. From our perspective, I just want to make sure that you guys fill it out for your buyers. And at the same time, if you guys are representing the sellers, make sure that when you get the executed contract or when you send it in for signatures, you also, especially if you have DocuSign, you can do that text format where you can just leave it blank and let them fill it out, right? That's the best way to do it.
Sounds good.
All right.
Oh,
All right.
one more thing on the bottom. If you keep scrolling down towards the end, the last couple sections, how do you handle that? Do you kind of leave it blank?
Which one?
There.
This
right there,
page,
last page.
Page 11. Yeah.
Option fee receipt, earnest receipt, all these.
Yep. That's going to be the title company is going to handle that.
Oh, okay.
Yeah. That's mainly for the title company. Yep. Absolutely. Yep. So.
I had one quick question. If it is a mud or a PID, does the realist tax say that?
It should. And that's a good question. So there's a website. I need to go find it. I was in a class maybe about a year ago. They actually shared a website that has all the different communities and all the taxing jurisdictions that have a mud or PID associated with it. Now, that actually brings up a very good point. When you talk to your sellers, especially if you're selling a listing in Artesia or some of the other parts of Prosper right now that have a mud or a PID, make sure you put that information in the listing, saying this property is subject to a PID or mud. The reason is, and make sure that the title company knows that too. Now, the title company, there's still a responsibility of the title company to make sure that they are putting that information down. But from our perspective, you want to make sure that you have that correct. Now, keep in mind, if you're representing a property in Artesia or some of these other communities, the best way to look at listings is see what everybody else did in the past, right? In other words, if you see, because remember in the listing, you have to put down if it's a mud, right? So go into the listings on Artesia and just look and see, did they add the yes disclaimer for the mud districts? And all of them do, they should. Does that make sense?
Not all. There's been
Not
a
all.
few I came across
Yeah.
up there near the Aubrey Prosper area where it was still, just city tax, I guess, right, rather than mother pit.
Yeah. Yeah. But if it's part of, and that's
The
where
Arrowhead, what is that? Arrowhead or Arrowview or wherever that subdivision?
I don't know where is that one? Arrowhead?
I just shared the link, that website that you can check them out so people can.
Oh, you did. Thank you. Which one is it? I know we had it. Yep, that's the one. Arcois. Yeah. Good. Thank you. And I just clicked on it too. Yeah. So guys, keep this link because that's great to have. Okay. And in fact, I'll share it. You know what? I'm going to share it with our team.
How do you download that link? Like,
Yeah. You know what I'll do is I'll save it and I'll send it with. You know what? Let me give me a minute, guys. I'm going to do that right now. So, and this is the mud PID link, right? Thanks, Hassan. That's great.
Yes, you're welcome.
Hang on one second. Okay. Save it for now. All right. Good. Thank you for doing that. All right. Let's go on to. We're going to spend just a few minutes on the what do you call it? The other contract here. Third-party financing. You guys are good, right? Haven't bored you yet? Let's see here. All right, so let's see, third-party financing. We've already talked about this in length. Make sure you guys have this filled out properly. Loan amount. The interest rate, remember, this is really just a cap, and I still think it's probably just now it's really just a useless version of it, because the problem is you don't have a lot of secondary mortgages, you don't have subprime, you don't have a lot of subprime lending. And this is just a historical thing. The reason you had this was, a buyer in the past 20 years ago, with the subprime lending at that time, they had excellent income, they had the assets, but they had horrible credit scores. So what lenders would do is they would say, yeah, you know what, I'll get you the loan as you planned, but I'm going to charge you 6% or 7%. So when you had this as a gap or a stopgap at, say, 5%, what that meant is if the lender was not able to bring that loan down based on the amount of percentage points that you were paying, then you were not obligated to buy the house. And that's what that meant for. It's really not used anymore. I personally don't think it's needed. Again, remember, 15 years is 15 years, 30 years is 30, 20 is 20. So make sure you're putting down the right information in here. Approval of financing. This is what we talked about, right? It's based on, and again, time is of the essence for this paragraph, and strict compliance with the time for performance is required. So make sure you don't fall out of contract because your buyer did not get the financing in time. Extremely important. And then, of course, the property condition approval. And there's that 3 days. And of course, that does not apply if you are doing a appraisal waiver. However, it does apply if you have a time limit on your appraisal waiver, which is section 3 of the appraisal. All right.
So Ketan, can you explain that a little bit? I'm a little confused. If you're giving the waiver, how can you then use that 3 days for the, for the property?
You can't. You can't, right? That's the reason for the waiver. And we're going to talk about the waiver here in a minute as well, because I think that's going to be very important. Yep. All right, let's go to the wire fraud warning. I don't use it. I've actually seen some of our agents use it, and probably because they've taken a class that explains it. So if somebody here has done that and taken a class that explains this, or one of the recent classes that goes over it, if you want to share, that would be awesome.
Yes.
I have. Who's taking it?
Yeah, I mean, I take it, and then I applied. Anytime that I submit the offer, I'm going to take this, and also the general information form. I attach both of this, get the sign with for the buyer, because
that's good.
Recently is lots of fraud is going on. The people is hacking the emails, so that's very important.
Yep. No, I agree completely. So that's good that you're doing that. So here's what I do that's a little bit different. I'll show you and I think you guys already have my next steps email, if I'm not mistaken, right? The next steps email is the one that, how do I get there? Oh, I see, it's just not, hang on. Hang on, guys. I'm going to see if I can pull up my next steps email. So on my next steps email, and I think I sent this to you guys recently, right? But and if you don't have it, please text me and I'll let you and I'll send it over to you guys. But this is a great email to have to share with your buyers. And again, here it is right there. Please do not wire funds without confirming the request and details are from a reliable source. All right. So and make sure and I actually put down, please read, because I want to make sure that your buyers are reading this or my buyers are reading it, right? In its entirety. That's one of the reasons it's there that way. All right. One more. Let's go through that. The addendum concerning right to terminate due to lender's appraisal. All right. You know what? I'm going to stop talking because I want you guys to explain it to me. So who wants to take on section number 1 and explain number 1 for me?
So this means the appraisal waiver means if, for example, the property is 500 and we put the offer for 550, and then we're going to say we have a full waiver of appraisal. That means if the property comes at 530, we're going to pay $20,000 gap between 530 to 550. For the second one, the partial waiver, that means that we put the gap, the maximum amount, which is, for example, if the property is 500, we put the offer for 530, we're going to say that, for example, 470, that's a gap.
So the house has to appraise more than 470, right? However,
Exactly.
if the house appraises less than 470, what happens?
The buyer can get out of contract.
Yep. Now, here is the portion of this. So then you still have to follow the third-party financing addendum as far as the termination. Does that make sense? The property approval condition.
Yes, and it's
Because
very
it says
important.
here, property
it's
approval is not obtained.
Exactly, and this addendum is just work with the conventional, so it's not going to work for FHA or VA. It's very important. I didn't know that. I just find out.
Yeah, that is correct. That's absolutely correct. Yeah, they don't say. I don't think they say it in here either. No, it is. It does. Does not involve FHA insured or VA financing. It does say it. It's in really, really small lines. All right, Hassan, you want to take on the section 3?
No, it's actually in big line and the first line itself, like on the top. If you read the first line, it is.
It is. I got to go get some new glasses. And you're right. It is right there too. Okay. All right. Hassan, you want to take on number 3?
Yes. For number 3, it says that for the way that the buyer, if does not, the lender cannot give a loan as far as the credit situation for the buyer, then at that situation is also the buyer is going to terminate this right for himself or for herself.
It's very similar to number 2. The only difference is there's a date, time, or time stamp that's associated with that. In other words, this forces the buyers to do the appraisal within 10 days after the effective date of the contract. Does that make sense? So that's what it says. We're going to do we're not going to wait till the last minute. We're not going to wait till the 3 days before closing to terminate. We're going to, do the appraisal within 10 days or 12 days or whatever it is. And at the same time, it has to appraise for, again, kind of what Hassan said, 470,000. All right. So that is, thank you. That's perfect. You guys.
So
you
why
got it
would
right away.
anybody do that? That third one, is it advantage for a buyer or?
So the only advantage to the buyer is, so it's not an advantage to the buyer. It's an advantage to the seller, because now you're saying that obviously the full waiver doesn't matter, right? At that point, the partial waiver, yeah, if it's going to be within, then I that's an issue as well. But the third one is not just a partial waiver, but it's a time-based partial waiver that says that no matter what, I'm going to go ahead and get my appraisal done within 10 days. So it's a benefit to the sellers as really not much of a benefit to the buyer, except for the fact that the buyer is getting the appraisal done very quickly, right? Because now you're not waiting all the way until the end to terminate if you have to. All right. Okay. Does that make sense? Did that help? Did that help a little bit? I don't know who was speaking.
It was me. Yes, it helped. Thanks.
All right. Thanks. All right. And I think that covers the amendment. We talked about that real quickly. Again, just sales price is number 1, repairs is number 2, date is number 3. Remember that. So here's a good thing that I need you guys to know is, let's say you represent the buyer and you guys have put down $1,500 on section 12 of the original contract. You come back, you have repairs, and you're asking for an additional $1,500 in repairs. What should this new number be? You always add it together, because if you don't, then it doesn't. Does that make sense? So if you had 1,500 initially, and then you're asking for an additional 1,500 after repairs, in lieu of repairs, then that number needs to be updated to $3,000.
This is for the settlement, right? This is for the additional settlement.
Yep,
Yeah.
exactly. And this is a huge mistake that a lot of people make, is they will think, oh, they forget the fact that they had $500 in the past, and then they ask for $1,500 and they just change it to $1,500. But in theory, you're changing it to $2,000. All right. So just remember that. It's very, very important to make sure that the math is done properly. Now, obviously, if the settlement the settlement cost section 12 had 0 on it, then whatever this number is a new number anyway. All right, cost of lender required repairs, that's really more towards the FHA. Buyer has paid an additional fee of, I usually put in $1, and then, obviously if I have to extend it a day or two, I'll just extend it, and then I'll just say will not be credited. And then another one that a lot of people will ask for is 7B, that, let's say, for example, if you have a 7-day option and you've delivered the repairs, the seller has agreed on day number 5, then they will ask you to do this, meaning that, at this point, we're officially under contract without any waivers. And here's the other one, the date for buyer to give written notice to seller that buyer cannot obtain buyer approval as set forth. And then this is the section 1, not the property condition approval, just the buyer approval. And this changes that to a certain number of days. All right. And then other modifications.
Ketan, I have a question on that 7.
Yeah.
So if the buyer decided not to do the inspection, or they have already finished their inspection and negotiation within that 7 or 5 day option period, do they really have to go and terminate the option period? They can just proceed with the next steps, right?
Yeah, if they don't have an option, then you just move on to the next steps automatically.
Okay. Because sometimes the seller might prefer to cancel the option period, but we don't really have to, right? We can just go ahead with the next step without canceling the option period.
Yeah. You can continue going on. Yeah. I mean, this would only be if the seller really, really asks for it. But to be honest, this past year or past 2 years, I've only had one person ask for it. And the only reason they were asking because they were relying on their attorney to explain everything to them, right? But in typical real estate world, it's usually not a concern. Most buyers, most sellers will not ask for it. Yeah. All right.
Ketan, quick question. My apologies, I missed that 12A1B, right? So let's say after inspection, the cost of repair comes $500. Did you say that in number 4? That number will be different than 400? Sorry, I missed that.
Nope, it'll be 500.
Okay.
So if the repairs come to 500, or if you agreed upon repairs, let's say you agreed that we're not going to do repairs, but we're just going to ask for money, then that $500 comes in there. Does that make sense? Yeah. But here's the thing: if you already had $500 in the original contract, then this needs to change to
1,000. Got it.
Okay. All right, guys, I know we're coming up on 7. Hopefully this helped. I know this was probably one of the more boring classes. The next 2 classes, no class on Monday. All right, so just remember that. No class on Monday. I will see you guys on Wednesday. And then I'm actually going to be on vacation for about 10 days. So we will have a class on, Wednesday, and then we won't have another class until the 21st. Sorry for that. I might be able to make it work. We'll see. Or I might have Rachel or somebody else do a class for us. All right, because we do want to continue going through this and not lose momentum. And I appreciate everybody joining these classes. I think hopefully it's helping, so All right, guys.
Yeah,
You guys are good.
definitely helping,
Thank you.
Ketan.
Thank you, Ketan. Thank you very much.
Thank you.
Ketan,
Bye.
one quick request.
Yeah, I'm gonna
Ketan,
call you.
like,
Bye-bye.
Okay.
Yeah, I'll call you. All right. All right, guys.
Good night.
Good night. Bye, guys.
Thank
Bye-bye.
you. Thank you, Ketan. Thank you so
Bye-bye.
much.
Thanks,
Bye-bye.
Ketan. Thanks.
Good night.
I'll see you
Ketan.
guys.
Thanks.